General Register. Number 188,550 August 19, 2013. Deutsche Bank AG Manila Branch, Petitioner versus Commissioner of Internal Revenue, Respondent. This is a petition for review filed by Deutsche Bank AG Manila Branch, Petitioner, under Rule 45 of the 1997 Rules of Civil Procedure assailing the Court of Tax Appeals en banc decision dated the 29th of May 2009 and resolution dated the 1st of July 2009 in CTA. AB number 456. The facts. In accordance with Section 28A, 5, of the National Internal Revenue Code of 1997, petitioner withheld and remitted to respondent on the 21st of October 2003 the amount of 67,688,553.51 pesos, which represented the 15% branch profit remittance tax on its regular banking unit net income remitted to Deutsche Bank Germany for 2002 and prior taxable years. Believing that it made an overpayment of the branch profit remittance tax, petitioner filed with the Bureau of Internal Revenue Large Taxpayers Assessment and Investigation Division on the 4th of October 2005 an administrative claim for refund or issuance of its tax credit certificate in the total amount of 22,562,851.17 pesos. On the same date, petition requested from the International Tax Affairs Division a confirmation of its entitlement to the preferential tax rate of 10% under the RP Germany Tax Treaty. Alleging the inaction of the Bureau of Internal Revenue on its administrative claim, petitioner filed a petition for review with the Court of Tax Appeals on the 18th of October 2005. Petition reiterated its claim for the refund or issuance of its tax credit certificate for the amount of 22,562,851.17 pesos representing the alleged excess branch profit remittance tax paid on branch profits remittance to Deutsche Bank Germany. The Court of Tax Appeals 2nd Division ruling. After trial on the merits, the Court of Tax Appeals 2nd Division found that petitioner indeed paid the total amount of 67,688,553.51 pesos representing the 15% branch profit remittance tax on its regular banking unit profits amounting to 451,257,023.29 pesos for 2002 and prior taxable years. Records also disclose that for the year 2003, petition remitted to Deutsche Bank Germany the amount of €5,174,847.38, or €330,175,961.88 pesos at the exchange rate of 63.804 pesos to €1, which is net of the 15% branch profit remittance tax. However, the claim of petitioner for a refund was denied on the ground that the application for a tax treaty relief was not filed with International Tax Affairs Division prior to the payment by the former of its branch profit remittance tax and actual remittance of its branch profits to Deutsche Bank Germany, or prior to its availment of the preferential rate of 10%, under the RP Germany Tax Treaty provision. The Court held that petitioner violated the 15-day period mandated under Section 3 Paragraph 2 of Revenue Memorandum Order No. 1-2000. Further, the Court of Tax Appeals 2nd Division relied on Murant, Philippines, Operations Corporation, formerly Southern Energy Asia Pacific Operations, PHILS, Incorporated, versus Commissioner of Internal Revenue, Murant, where the Court of Tax Appeals en banc ruled that before the benefits of the tax treaty may be extended to a foreign corporation wishing to avail itself thereof, the latter should first invoke the provisions of the tax treaty and prove that they indeed apply to the corporation. The Court of Tax Appeals en banc ruling. The Court of Tax Appeals en banc affirmed the Court of Tax Appeals 2nd Division's decision dated the 29th of August 2008 and resolution dated the 14th of January 2009. Citing Murant, the Court of Tax Appeals en banc held that a ruling from the International Tax Affairs Division of the Bureau of Internal Revenue must be secured prior to the availment of a preferential tax rate under a tax treaty. Applying the principle of stare decisis et non quieta movia, the Court of Tax Appeals en Banc took into consideration that this court had denied the petition in General Register number 168,531 filed by Mrent for failure to sufficiently show any reversible error in the assailed judgment. The Court of Tax Appeals en Banc ruled that once a case has been decided in one way, any other case involving exactly the same point at issue should be decided in the same manner. The court likewise ruled that the 15-day rule for tax treaty relief application under Revenue Memorandum Order No. 1-2000 cannot be relaxed for petitioner, unlike in CBK Power Company Limited vs. Commissioner of Internal Revenue. In that case, the rule was relaxed and the claim for refund of excess final withholding taxes was partially granted. While it issued a ruling to CBK Power Company Limited after the payment of withholding taxes, the International Tax Affairs Division did not issue any ruling to petitioner even if it filed a request for confirmation on 4 October 2005 that the remittance of branch profits to Deutsche Bank Germany is subject to a preferential tax rate of 10% pursuant to Article 10 of the RP Germany Tax Treaty. Issue. This court is now confronted with the issue of whether the failure to strictly comply with Revenue Memorandum Order No. 1-2000 will deprive persons or corporations of the benefit of a tax treaty. The court's ruling. The petition is meritorious. Under Section 28A(5) of the National Internal Revenue Code, any profit remitted to its head office shall be subject to a tax of 15% based on the total profits applied for or earmarked for remittance without any deduction of the tax component. However, petitioner invokes paragraph 6, Article 10 of the RP Germany Tax Treaty, which provides that where a resident of the Federal Republic of Germany has a branch in the Republic of the Philippines, this branch may be subjected to the branch profits remittance tax withheld at source in accordance with Philippine law but shall not exceed 10% of the gross amount of the profits remitted by that branch to the head office. By virtue of the RP Germany Tax Treaty, we are bound to extend to a branch in the Philippines, remitting to its head office in Germany, the benefit of a preferential rate equivalent to 10% branch profit remittance tax. On the other hand, the Bureau of Internal Revenue issued Revenue Memorandum Order No. 1-2000, which requires that any availment of the tax treaty relief must be preceded by an application with International Tax Affairs Division at least 15 days before the transaction. The order was issued to streamline the processing of the application of tax treaty relief in order to improve efficiency and service to the taxpayers. Further, it also aims to prevent the consequences of an erroneous interpretation and/or application of the treaty provisions, that is, filing a claim for a tax refund, credit for the overpayment of taxes or for deficiency tax liabilities for underpayment. The crux of the controversy lies in the implementation of Revenue Memorandum Order No. 1-2000. Petitioner argues that, considering that it has met all the conditions under Article 10 of the RP Germany Tax Treaty, the Court of Tax Appeals erred in denying its claim solely on the basis of Revenue Memorandum Order No. 1-2000. The filing of a tax treaty relief application is not a condition precedent to the availment of a preferential tax rate. Further, petitioner posits that, contrary to the ruling of the Court of Tax Appeals, Mrent is not a binding judicial precedent to deny a claim for refund solely on the basis of non-compliance with Revenue Memorandum Order No. 1-2000. Respondent counters that the requirement of prior application under Revenue Memorandum Order No. 1-2000 is mandatory in character. Revenue Memorandum Order No. 1-2000 was issued pursuant to the unquestioned authority of the Secretary of Finance to promulgate rules and regulations for the effective implementation of the National Internal Revenue Code. Thus, courts cannot ignore administrative issuances which partakes the nature of a statute and have in their favor a presumption of legality. The Court of Tax Appeals ruled that prior application for a tax treaty relief is mandatory, and non-compliance with this prerequisite is fatal to the taxpayer's availment of the preferential tax rate. We disagree. A minute resolution is not a binding precedent. At the outset, this court's minute resolution on MRNT is not a binding precedent. The court has clarified this matter in Philippine Healthcare Providers, Incorporated versus Commissioner of Internal Revenue as follows. It is true that, although contained in a minute resolution, our dismissal of the petition was a disposition of the merits of the case. When we dismissed the petition, we effectively affirmed the Court of Appeal's ruling being questioned. As a result, our ruling in that case has already become final. When a minute resolution denies or dismisses a petition for failure to comply with formal and substantive requirements, the challenged decision, together with its findings of fact and legal conclusions, are deemed sustained. But what is its effect on other cases? With respect to the same subject matter and the same issues concerning the same parties, it constitutes res judicata. However, if other parties or another subject matter, even with the same parties and issues, is involved, the minute resolution is not binding precedent. Thus, in CIR versus Nickel, the court noted that a previous case, CIR versus Nickel involving the same parties and the same issues, was previously disposed of by the court through a minute resolution dated February 17, 2003 sustaining the ruling of the Court of Appeals. Nonetheless, the court ruled that the previous case had no bearing on the latter case because the two cases involved different subject matters as they were concerned with the taxable income of different taxable years. Besides, there are substantial, not simply formal, distinctions between a minute resolution and a decision. The constitutional requirement under the first paragraph of Section 14, Article 8 of the Constitution that the facts and the law on which the judgment is based must be expressed clearly and distinctly applies only to decisions, not to minute resolutions. A minute resolution is signed only by the clerk of court by authority of the justices, unlike a decision. It does not require the certification of the Chief Justice. Moreover, unlike decisions, minute resolutions are not published in the Philippine reports. Finally, the proviso of Section 4(3) of Article 8 speaks of a decision. Indeed, as a rule, this court lays down doctrines or principles of law which constitute binding precedent in a decision duly signed by the members of the court and certified by the Chief Justice. Even if we had affirmed the Court of Tax Appeals in MRNT, the doctrine laid down in that decision cannot bind this court in cases of a similar nature. There are differences in parties, taxes, taxable periods, and treaties involved. More importantly, the disposition of that case was made only through a minute resolution. Tax Treaty versus Revenue Memorandum Order No. 1/2000. Our Constitution provides for adherence to the general principles of international law as part of the law of the land. The time-honored international principle of pacta sunt servanda demands the performance in good faith of treaty obligations on the part of the states that enter into the agreement. Every treaty in force is binding upon the parties, and obligations under the treaty must be performed by them in good faith. More importantly, treaties have the force and effect of law in this jurisdiction. Tax treaties are entered into to reconcile the national fiscal legislations of the contracting parties and, in turn, help the taxpayer avoid simultaneous taxations in two different jurisdictions. CIR versus SC. Johnson & Son, Incorporated further clarifies that tax conventions are drafted with a view towards the elimination of international juridical double taxation, which is defined as the imposition of comparable taxes in two or more states on the same taxpayer in respect of the same subject matter and for identical periods. The apparent rationale for doing away with double taxation is to encourage the free flow of goods and services and the movement of capital, technology and persons between countries, conditions deemed vital in creating robust and dynamic economies. Foreign investments will only thrive in a fairly predictable and reasonable international investment climate, and the protection against double taxation is crucial in creating such a climate. Simply put, tax treaties are entered into to minimize, if not eliminate, the harshness of international juridical double taxation, which is why they are also known as double tax treaty or double tax agreements. a state that has contracted valid international obligations is bound to make in its legislations those modifications that may be necessary to ensure the fulfillment of the obligations undertaken. Thus, laws and issuances must ensure that the reliefs granted under tax treaties are accorded to the parties entitled thereto. The Bureau of Internal Revenue must not impose additional requirements that would negate the availment of the reliefs provided for under international agreements. More so, when the RP Germany tax treaty does not provide for any prerequisite for the availment of the benefits under said agreement. Likewise, it must be stressed that there is nothing in Revenue Memorandum Order No. 1/2000 which would indicate a deprivation of entitlement to a tax treaty relief for failure to comply with the 15-day period. We recognize the clear intention of the Bureau of Internal Revenue in implementing Revenue Memorandum Order No. 1/2000, but the Court of Tax Appeals' outright denial of a tax treaty relief for failure to strictly comply with the prescribed period is not in harmony with the objectives of the contracting state to ensure that the benefits granted under tax treaties are enjoyed by duly entitled persons or corporations. Bearing in mind the rationale of tax treaties, the period of application for the availment of tax treaty relief as required by Revenue Memorandum Order No. 1/2000 should not operate to divest entitlement to the relief, as it would constitute a violation of the duty required by good faith in complying with the tax treaty. The denial of the availment of tax relief for the failure of a taxpayer to apply within the prescribed period under the administrative issuance would impair the value of the tax treaty. At most, the application for a tax treaty relief from the Bureau of Internal Revenue should merely operate to confirm the entitlement of the taxpayer to the relief. The obligation to comply with the tax treaty must take precedence over the objective of Revenue Memorandum Order No. 1/2000. Logically, non-compliance with tax treaties has negative implications on international relations and unduly discourages foreign investors. While the consequences sought to be prevented by Revenue Memorandum Order No. 1/2000 involve an administrative procedure, these may be remedied through other system management processes, for example, the imposition of a fine or penalty. But we cannot totally deprive those who are entitled to the benefit of a treaty for failure to strictly comply with an administrative issuance requiring prior application for tax treaty relief. Prior application versus claim for refund. Again, Revenue Memorandum Order No. 1/2000 was implemented to obviate any erroneous interpretation and/or application of the treaty provisions. The objective of the Bureau of Internal Revenue is to forestall assessments against corporations who erroneously availed themselves of the benefits of the tax treaty but are not legally entitled thereto, as well as to save such investors from the tedious process of claims for a refund due to an inaccurate application of the tax treaty provisions. However, as earlier discussed, non-compliance with the 15-day period for prior application should not operate to automatically divest entitlement to the tax treaty relief, especially in claims for refund. The underlying principle of prior application with the Bureau of Internal Revenue becomes moot in refund cases, such as the present case, where the very basis of the claim is erroneous or there is excessive payment arising from non-availment of a tax treaty relief at the first instance. In this case, petitioner should not be faulted for not complying with Revenue Memorandum Order No. 1/2000 prior to the transaction. It could not have applied for a tax treaty relief within the period prescribed, or 15 days prior to the payment of its branch profit remittance tax, precisely because it erroneously paid the branch profit remittance tax not on the basis of the preferential tax rate under the RP Germany tax treaty, but on the regular rate as prescribed by the National Internal Revenue Code. Hence, the prior application requirement becomes illogical. Therefore, the fact that petitioner invoked the provisions of the RP Germany tax treaty when it requested for a confirmation from the International Tax Affairs Division before filing an administrative claim for a refund should be deemed substantial compliance with Revenue Memorandum Order No. 1/2000. Corollary thereto, Section 229 of the National Internal Revenue Code provides the taxpayer a remedy for tax recovery when there has been an erroneous payment of tax. the outright denial of petitioner's claim for a refund, on the sole ground of failure to apply for a tax treaty relief prior to the payment of the branch profit remittance tax, would defeat the purpose of Section 229. Petitioner is entitled to a refund. It is significant to emphasize that petitioner applied, though belatedly, for a tax treaty relief, in substantial compliance with Revenue Memorandum Order No. 1-2000. A ruling by the Bureau of Internal Revenue would have confirmed whether petitioner was entitled to the lower rate of 10% branch profit remittance tax pursuant to the RP Germany tax treaty. Nevertheless, even without the Bureau of Internal Revenue ruling, the Court of Tax Appeals 2nd Division found as follows. Based on the evidence presented, both documentary and testimonial, petitioner was able to establish the following facts. A. That petitioner is a branch office in the Philippines of Deutsche Bank AG, a corporation organized and existing under the laws of the Federal Republic of Germany. B. That on October 21, 2003, it filed its monthly remittance return of final income taxes withheld under Bureau of Internal Revenue Form No. 1601F and remitted the amount of 67,688,553.51 pesos as branch profits remittance tax with the Bureau of Internal Revenue, and c. That on October 29, 2003, the Banco Central ng Pilipinas, having issued a clearance, petition remitted to Frankfurt head office the amount of €5,174,847.38, or €330,175,961.88 pesos at 63.804 peso per euro, representing its 2002 profits remittance. The amount of peso 67,688,553.51 paid by petitioner represented the 15% branch profit remittance tax on its regular banking unit net income, due for remittance to Deutsche Bank Germany amounting to peso 451,257,023.29 for 2002 and prior taxable years. Likewise, both the administrative and the judicial actions were filed within the 2-year prescriptive period pursuant to Section 229 of the National Internal Revenue Code. Clearly, there is no reason to deprive petitioner of the benefit of a preferential tax rate of 10% branch profit remittance tax in accordance with the RP Germany tax treaty. Petitioner is liable to pay only the amount of 45,125,702.34 pesos on its regular banking unit net income amounting to 451,257,023.29 pesos for 2002 and prior taxable years, applying the 10% branch profit remittance tax. Thus, it is proper to grant petitioner a refund of the difference between the 67,688,553.51 pesos, 15% branch profit remittance tax, and 45,125,702.34 pesos, 10% branch profit remittance tax, or a total of 22,562,851.17 pesos. Wherefore, premises considered, the instant petition is granted. Accordingly, the Court of Tax Appeals en banc decision dated the 29th of May 2009 and resolution dated the 1st of July 2009 are reversed and set aside. A new one is hereby entered ordering Respondent Commissioner of Internal Revenue to refund or issue a tax credit certificate in favor of petitioner Deutsche Bank AG Manila branch the amount of 22,562,851 pesos and 17 centavos, Philippine currency, representing the erroneously paid branch profit remittance tax for 2002 and prior taxable years. So ordered.